Thank you, Stephanie, and good morning, everyone. Good afternoon to those of you who are on the East Coast, and welcome to our course. My name is James Diamond, and I'm the Dean of Academic Affairs for the National Tribal Trial College. I'd like to thank the National Council of Juvenile and Family Court Judges for hosting us today. I am with the National Tribal Trial College, which is a program of the Southwest Center for Law and Policy. The Southwest Center runs the National Tribal Trial College and many other programs, like a really important program called SafeStar you want to find out about. This course is report writing for tribal law enforcement in domestic and sexual violence cases. Let me tell you just a little bit about me before I dive right in. I'm an attorney and a law professor. I am a former prosecutor. I started out with the New York State Attorney General, and then I was a state's attorney in Connecticut, prosecuting domestic violence and sexual violence and all kinds of cases. I then was a defense attorney for many years. I got a doctoral degree in indigenous law, and then was a tribal prosecutor and ran a tribal law clinic. I now teach here at the Tribal Trial College and at Roger Williams Law School. Okay, so our subject, report writing for tribal law enforcement. And in fact, much of what I say applies to law enforcement everywhere. But we have particular concerns when we have tribal victims and in Indian country, so we will cover those in great detail. Your goal in law enforcement in domestic violence cases and sexual violence cases is to build a successful case for prosecution. I want you to think of me as your prosecutor, and I'm not out in the field investigating the case. You are. Some of you might be victims advocates as well, and so you pay attention certainly to all the details that help law enforcement. But think of me as the prosecutor. I'm not in the field. I'm not talking to the witnesses. I'm not collecting the evidence. But what we're talking about here today is writing reports that can be used for prosecution. Remembering that in Indian country, police officers, law enforcement might be enforcing laws that are either federal law, state law, or tribal law. Case law and statutes. The interesting thing about law enforcement in Indian country is that you don't always know, as a law enforcement officer, who's going to be taking your reports and using them for prosecution. The tribal officer is typically the first on the scene. Oftentimes knows the people, the parties involved the best, knows the status of the land the best, and the status of the land is really significant in prosecuting on Indian reservations or on tribal land, because from one parcel to the next may determine the difference of who's going to take over that case from law enforcement and prosecute it, right? So you may be enforcing tribal code, state statute, or federal law, and that's due to the complexity of working in law enforcement in Indian country. Okay, so you're doing your investigation of domestic violence, of a domestic assault, or a sexual assault, and you want to be documenting your investigation at every step of the way. So you're documenting before you interview witnesses, after you take statements, You're documenting your investigation after you take pictures. You secure the crime scene. You're accumulating physical evidence and forensic evidence. You're doing interviews with your victim and the suspect as well. So you document your investigation. And what you're going to do is take written notes in the field. And most of the time it's in a notebook, right? Some departments may have you taking notes on a computer in a police car. But typically you're writing down written notes in the field and you save them. And you go from writing your notes to writing a police report, okay? And your police reports document your investigation. You're going to have preliminary reports, and then you're going to have follow-up reports, okay? But your police reports are going to take several forms, right? In this kind of case, and all kinds of investigations. So first, field reports are handwritten, and you save them, and you're going to use them to prepare your supplemental narrative reports. Typically you've got a cover sheet, a computerized form for your department, and it's and you're checking off boxes. And domestic violence is typically one of those boxes, but you check off the appropriate boxes on your sort of, I call it a cover sheet. It's a form, right? But remember, you might be adding some detail to that form, and that form should be consistent with the greater details that are in your supplemental reports. But you start out with sort of a cover sheet. Just remember that your report should be consistent all the way through. And if you've forgotten to check off a box, go back and do that later. So a reminder in all violence cases that everything the suspect says is important. Okay? Everything the suspect says is important. Whether those are truthful admissions or non-truthful admissions, lies, they're important because you don't know when the case is handed over to a prosecutor, right? You might be, something the suspect says and is not truthful, but still may end up proving, a part of the crime. And what we'll get to in a minute as elements of the offenses. You may end up in an inconsistent statement or a lie. You may end up proving one or more elements that are required to prove sexual assault or domestic violence. So the inconsistent statements or the untruthful statements of a suspect in a sexual assault case still are important for you to write down. And the words of the suspect are almost always allowed in court, and therefore you write them down. Okay. Now, in these kinds of cases, you're going to have to establish that you're in Indian country. You're on tribal lands. So if you're prosecuting, if you're investigating a case that's prosecuted in a tribal court, the incident has to have occurred on tribal lands. Now, you may end up, like I said, handing the case over to a prosecutor that's not a tribal prosecutor. It's still, you've got to document exactly where it occurred. If it's an assault, where exactly it occurred, because from one piece of property to the next can determine whether you're going to end up with that case in tribal court or federal court or another court. Okay, so you've got to document in your police report exactly where the incident took place. And if it moved from one place to another, you've got to document that as well, as maybe only a part of the incident occurred in Indian country. Maybe you crossed over. Look, we all know that tribal lands have borders. You may move from one to the other. You may move from one side of the reservation to the other. You may move, for example, like maybe the reservation is bordered by, a field or a river, and on the other side of the river is a different reservation or is not tribal land. So you've got to document exactly where it occurred when we're talking about domestic violence or sexual violence in these kinds of cases. Oh, and also, your suspect has to be, in order to prosecute in tribal court, has to be an Indian. And so, unless we're talking in recent years, domestic violence prosecutions in tribal court are starting to allow prosecution of non-Indian offenders, but it's very, very limited. Only about 20 places right now. And maybe someday in the future that will change. We certainly hope so. But you've got to establish that your offender is Indian. So the most common way to do that, the easiest way to do that, is to document that your offender is an enrolled citizen in a federally recognized tribe. Now, that's not the only way, but it gets way more complicated if your offender is not an enrolled member of the tribe. Now, these are sorts of things you can find out, but remember, you may be the first on the scene investigating a domestic violence case, and it may end up being prosecuted not in tribal court. So you continue your investigation whether or not you have an Indian offender or not, because you may end up in state court in certain locations, and you may end up in federal court. So you have to know whether your offender is Indian or not, and make a phone call. Okay. Easiest way to do that is to call the tribal enrollment office and find out, and take the enrollment number and put it in your report. That's probably got a box on that first page of the form, the enrollment number of the offender, and if the offender is non-Indian, put that in the report as well. Okay, your report needs to be detailed. Remember, this prosecution may be months from now, or even years from now. And so put the details of your investigation in your report. Don't rely on your memory. It's fresh in your mind that afternoon when you're at the scene of a domestic violence assault. It's fresh on your mind right then and there, and you think you're going to remember. But 3 months from now, you've had 26 more cases, and some of the details you're not going to remember. Those police reports are going to be how you can use those details in court. Your report should be easy to read. You type them out, right? And correct typos, spelling counts. Hate to be a nudge. Try to avoid, the legal jargon like wherefore, henceforth, those sorts of words. Use short sentences. Don't have your report be one long, sentence with commas. Break it up into short sentences. Put quotation marks around the actual words of the witnesses. Now that's really important because the actual words of the suspect in a domestic violence case, the actual words of the victim, the witnesses are going to be the subject of examination in court. The judge wants to hear exactly what was said. The judge wants to hear exactly what was told to you during your investigation. And the words really matter. They really count. So put quotation marks around the actual words of what was told to you. They also, when it comes to an eyewitness or a victim of a sexual assault or domestic violence assault, those quotation marks tell us that we have, give the judge and the prosecutor a flag that we might be talking about hearsay, and we have to try to figure out whether the hearsay is going to be allowed in court or not. So hearsay is a rule of evidence, and typically hearsay is not allowed to be evidence in court, but there are exceptions to all rules, and something like hearsay is a rule of evidence that restricts out-of-court statements from being testified to, unless there's an exception. But something like an excited utterance, something someone says when they're really excited, like "Damn it, you hit me!" Is an excited utterance, and so we might allow that in. Your police reports should be your version of your investigation. So write them in the first person. When I got to 49 Main Street, I entered the residence. I noticed 3 young children. They appeared to be in distress. I asked where their mother was, and I was pointed in the direction of a woman who turned out to be Samantha Jones. So you write the reports in the first person, what you saw and who you spoke to. I spoke to Samantha Jones, who told me her husband came home intoxicated and assaulted her, for example. So write your reports in the first person. If you learn something from another officer, then put that in your report. I learned from Officer Smith that the suspect was seen leaving the reservation by Rural Road 22. Or Officer Jones told me that he called the tribal administrator's office and found out that the offender is a member of the Mashantucket Pequot tribe. So put that in your report just like that. I called the tribal administrator, who told me the house is owned by the tribe, and that is in fact tribal lands. So if you found out that the house was owned by the tribe, or the house is owned by a private property owner, so don't just put the conclusion in your report that the house is tribal land. Tell me in the report, tell me, the prosecutor, how you found that out. Okay, in your report, your police report, you're sticking to those 5 W's, right? Documenting the offense: who, what, when, where, why, and how. Now, who assaulted her? When was she assaulted? What time? What time did he come home? Where exactly did the assault start? Now, the why is not as important in real life as it is on television. Motive, but it can be important because we, so many offenses, we need to know what the intent of the offender is. So, the intent to, when someone strikes someone with the intent to cause an injury. So that's the why. But the motivations are not as important as they are as I said, on television. And I think my police officer friends know that. How did an injury occur? How did the offender cause the injury? That's really important, and really important for you to be detailed. We want you to consider making a sketch, and this gets a little more involved, but it's part of police reports, and that's why I included it in my talk today. And you're going to make a rough sketch of the room where the assault took place. You do want to have tape measure handy to make measurements, but you're going to take make a rough sketch to begin with, and it's not to scale. Now, let me show you a sample of one here. Here we go. Here's a rough sketch. Remember, you're not Da Vinci. You don't have to be like the best artist on your reservation. It's rough. You show me where the things in the room exist and so I can tell where the assault took place and how close the table was, how close the weapon was. For example, if there's other evidence that was located in the room, where it was, and you'll make a rough sketch by hand. Now, many departments have sophisticated software to make a more formal sketch, more formal diagram, and if you have that, that's great. But your sketch wants to indicate where the important evidence was located. If there's a weapon left behind, you want to indicate where that was. If there is let's just say the assault started, in the kitchen, and there's evidence of blood moving from the kitchen to the living room. You want to mark that off on a sketch. Remember, it doesn't have to be a final sketch, and it doesn't have to be artistic, but you should, in fact, take measurements. Okay. Your report needs to be honest. Now, anyone who's taken a course from me before, and by the way, I note that I have several of my former students here in the room. I see you here, and welcome my former students, whether that's my former students in the trial advocacy program, the victims advocacy program that we do once a year, usually at the University of Wisconsin Law School, or you're my students at Roger Williams Law School or at the University of Arizona. I welcome my students, but any of my students know, or you've taken one of my webinars before, any of my students know that I always talk about this, that you want your domestic violence case, you want your sexual violence case, your sexual assault case to be successful when it's turned over to the prosecutor. But there might be part of the investigation that you just haven't figured out, or you don't know, and you don't exaggerate that in your reports. Your reports need to be accurate and they need to be complete, but you don't exaggerate because of how badly you want to be successful. Honesty is critical. You want the judge to believe you when you end up testifying. And your reputation for being reliable, for being honest, and being truthful is gold. It's worth its weight in gold. Because a bad reputation for honesty follows with you, and you're not of much use to any prosecutor if your reports are not honest. The importance of a good reputation takes years to build and minutes to ruin. One lie in a police report. And I don't think it happens very often, but it's happened to me where, a piece of evidence didn't exist, and yet it was claimed to be something that wasn't in a report. People talk, and certainly in this field, this is a small field. You go to conferences where you talk to other tribal police officers, you talk to prosecutors, and people remember, and prosecutors and judges talk. And so you want a reputation for honesty. And if you're not honest, that may blow the case. The evidence may be disqualified, or the case may be dismissed. But you could lose your job. So you don't want to exaggerate, and you don't want to be dishonest. Okay, I've said enough about that. Let's move on. Your reports have. This is really important. A prosecutor taking your reports has to be able to establish the elements of domestic violence or the elements of a sexual assault. And all causes of action in law, and domestic violence is a cause of action, sexual assault is a cause of action. All causes of action, all crimes have elements, okay? And I want you to think of them as building blocks. Okay, here's my slide. I want you to think of them as bricks, okay? And a domestic violence case is put together like a builder builds a brick wall, one brick on top of another, and every one of those bricks is necessary. Every one of those elements is necessary. Otherwise, that wall is going to crumble. So, by the way, this is a concept that we have borrowed from science. Law borrowed from science. It's a good thing that I don't have to become an expert in this science, because I'm not that good at science. I'm good at law. But for example, everything on the planet is made up of elements, like water, for example. The water molecule has hydrogen and oxygen, right? The elements are the hydrogen and the oxygen. So it's the same thing with a sexual assault. It's the same thing with domestic violence. It's made up of elements. And in your report, you have to establish those elements. I'm going to tell you what they are in a minute. But those elements, let's just take a burglary, for example. It's an easy one. Burglary is, entering a building with the intent to commit a crime inside. Enter, building, intent to commit a crime inside. Those are the elements, okay? And your report has to prove each and every one of those elements with evidence. Your evidence is your testimony, the physical items, your statements from your witnesses, maybe reports, forensic reports of examination, etc. That's your evidence. Your evidence is used to prove those elements, right? Elements, again, you build one on top of another. Okay, so sexual assault has elements that you have to prove with evidence. Sexual assault is when a person has sexual contact with another person without consent. That's it. Okay? That's it. Without consent, or they're unable to consent. Now, Sexual contact in your tribal code is going to have a definition. It might have, it's going to have a definition in state law if that's where your case ends up, and it has a definition in federal law. So you need to be familiar with those definitions. But we know that sexual contact, for the most part, there's different kinds of sexual contact, and depending on the kind of sexual contact that the offender did to the victim, makes it more or less serious. But for example, if it is contact with private genitalia, and it's just contact, that's going to be less serious than if there's a physical injury. It's going to be more serious if there's a physical injury. If the contact is sexual intercourse, then it's going to be more serious than if it's contact. Okay, and sexual intercourse is also going to be defined in your tribal law. It's going to be defined in your state law. It's going to be defined in federal law. That lack of consent is something you're going to prove. If you're going to prove it by the fact that it was forced, compelled, without permission, perhaps the victim is not conscious or is unable to consent because they're under the influence, or they're a child, and so they're not competent legally to be able to give consent. Again, those are the elements of sexual assault. Your report must establish the elements of either a sexual assault or domestic violence. So you've got to be familiar with your code that has there's definitions, and domestic violence also has those elements defined, and your report has to establish those elements, whether it's going to be in your report or the report of some other officer. In your report, you have to document exactly what the victim said about the assault. Now, it's not, this could have gone on for hours. It could have started and stopped and then continued. And those facts and circumstances and the specifics of how your victim, male or female, was attacked is something that you are going to put in your narrative reports. Remember, I said there's a form that you start with, and then subsequent reports, your narrative reports. So be very specific about whether the victim was conscious or unconscious during the assault. Go back later and add details that maybe you forgot to include in the beginning, or details that you learned from subsequent investigation. Domestic violence. What is it? I don't want to gloss over this. We remember, again, you're a tribal officer, and your reports might get turned over to federal prosecutors, and they might get turned over to state prosecutors, depending on where you are. Just a minute about state prosecutors. I was one. The rule of thumb in Indian country is, most of the time your case is going to be prosecuted by either a tribal prosecutor or a U.S. attorney, a federal prosecutor, because most of the cases are not going to state court unless you're in what we call a PL-280 state, or a handful of those states in the Northeast where the states have assumed criminal jurisdiction in Indian country. If you are in a state that's PL-280 state, you want to know that. You ask your supervisor immediately if you are. California, Alaska, Wisconsin, Minnesota. There's about a dozen. And these are states where in the 1950s the Congress gave jurisdiction to state courts. It's not the rule of thumb. The rule of thumb is you're in tribal court or you're in federal court. But, like I said, you never know. If your offender, if your offender is not Indian, right? Your victim is a indigenous woman, and your offender is a non-Indian man. Well, then you may end up in state court if you're not in a VAWA tribal court. So know the code where you're in. Know whether you're going to state court, federal court, or tribal court. Now, if this sounds complicated, it's because it is, and it's a complexity that makes our life in this field challenging and difficult. But it is surmountable, and you can get over this obstacle. And so, anyway, domestic violence has definitions, has elements also. Violence committed by a spouse, current or a former spouse, or an intimate partner, or someone that shares a parenting with of a child, who lives together, cohabitates together with the victim or their intimate partner, and also under federal law, by a person who's acting like a spouse, they're intimate partners, and in a place where in Indian country where the violence occurred. Now, in your tribal courts, most tribes have a domestic violence code. Not all, and if you think that that's something that would help, talk to your counsel about adding a domestic violence code. It certainly would help. If you prosecute domestic violence in tribal court, you need a code. Many tribes have their own domestic violence code. Here's an example of one: the Grand Traverse Band of Ottawa Chippewa Indians. And so remember, the definition is going to differ, and so your elements are going to differ a little bit based on your tribal code. But if you're at Grand Traverse, for example, and you engage in violence against a family member or a household member or someone with an intimate relationship or a dating relationship, and you now look at this. At Grand Traverse, even attempting or causing injury to a pet is domestic violence. Okay? That's not the case in most places, but it is there. Someone who is attempting property damage at Grand Traverse. Now, within the definitions of domestic violence, you may have separate crimes. Like, for example, at Grand Traverse, a person who's inflicting injury or places someone in reasonable fear of an assault or stalking is committing domestic violence. Now, stalking may be a separate crime defined in the Grand Traverse Code. It is. You may have several offenses within one incident, and so you may have your intimate partners. You may have a domestic violence crime. You may have an assault. You may have disorderly conduct, and you may have stalking. They may be separate crimes that are prosecuted separately, additionally, or it's part of the domestic violence element itself. And that's something to be familiar with as well. But you're putting those in your reports. Now, your reports have to establish the domestic violence. So in domestic violence cases, you have to document in your report the relationship, okay? The family relationship, the dating relationship, the intimate relationship. You can't leave that out. And so you have to ask your victim, how long have the two of you been seeing each other? How long have you been living together? Perhaps you might have to document that he lives there. Where does he keep his clothes? Are his clothes in the dresser? How often does he stay here? I say he, and it's not always a man on a woman. We know. How often does she live here? Rarely, but occasionally might you ask that question. But you might. It could be domestic violence of a same-sex couple. How often does she live here? How often does he live here? How often does he stay here? Are those his clothes in the closet? Are those his clothes in the dresser? Is that his mail on the counter? Are those his shoes? And in establishing domestic violence, you want to investigate the case. And you want to investigate tactics of abuse, okay? That can be physical abuse. It can be intimidation. There can be threats that are made. If you ever think of leaving this house again, I'm going to kill you. Economic abuse is an important aspect of domestic abuse. A husband or a spouse or a boyfriend who maintains control over a victim by not allowing her access to a bank account, or the mail. Might be cultural abuse, might be ritual abuse. There might be, harming her because he doesn't like Indians, for example. Those are things that you document. But that relationship I said a minute ago, the family relationship, the fact that the person, usually lives there, usually stays there, is something that has to be documented. Document that by asking the questions or asking, other witnesses. Okay. Now, in establishing and working on a domestic violence case in Indian country or anywhere, you might want to call a victim's advocate. Now, victim's advocates might work for, I'm sorry to skip over the slides, might work for the court. The victim's advocate might work for your police department, might work for the prosecutor's office. But find out if you've got a victim's advocate who can help, because victim's advocates can be so helpful in so many ways. A victim's advocate can help your victim get help, get support, get emotional help and support as she goes through this horrific nightmare of a sexual assault. Might be able to help with resources, compensation. Might help with, dealing with other witnesses, with landlords, creditors. Maybe make a plan for the future. Maybe help get into a shelter. Might maybe help with medical appointments and health insurance and so much. So think about calling a victim's advocate. Remember that what's told to a victim's advocate is usually not confidential, just as what's told to a police officer is not confidential, as opposed to a lawyer or a doctor, where there is a privilege of confidentiality in the law. But there's so much that a victim's advocate can help with, and so I encourage you to find out who your victim's advocates are and who's on call. Typically, there's a victim's advocate that's on call, can help you with so much, can be so supportive for your victim of sexual violence or domestic violence. Your offense might be a hate crime, and you want to document that as well. A hate crime is an offense committed by a person that's motivated by a bias based on race, ethnicity, color, religion, gender, sexual orientation, national origin, or disability. If you have if there's an assaulter who, is homophobic and attacks your victim who's homosexual, that's a hate crime. If that's the reason for the assault. The reason why I bring this up is because a hate crime, in addition to the other penalties that exist, might enhance the penalties, make it worse for the offender. I just want to talk for a second about enhancement. I don't have a tremendous amount of time left, but just on the subject of enhancement, of penalties in Indian country, I want to take note of the fact that an important person passed away last week, a couple of days ago, and that's Ruth Bader Ginsburg. And I didn't agree with Justice Ginsburg on everything, but I did agree with her when it came to indigenous women and violence. And Justice Ginsburg wrote a decision, U.S. versus Bryant, about enhancing penalties against offenders in Indian country when they are recidivist offenders, when they are repeat offenders. U.S. versus Bryant. You write that down, bring it up with your prosecutors, and just paying tribute for a moment to Justice Ginsburg, who helped law enforcement and victims in this way. Enhancement. Penalties are enhanced if someone is a repeat offender for domestic violence or sexual violence. So that's something for you to pay attention to as well. If you have a repeat offender. And anyway, I didn't want to let this opportunity go without paying tribute to Justice Ginsburg for a moment. When you've got a suspect, you document your interrogation. We did a whole webinar on this last month, so I'm not going to spend too much time on that today. Document your interrogation of the suspect. Document, take down a confession or an admission in writing and make it part of your report. If you've got an interrogation and a statement you're attempting to get from an offender, even if the offender refuses to sign that statement, make it part of your report and include that in your report. And anything that the suspect tells you about the assault is going to be important. And you never know. If an offender in a sexual assault case first denies having sexual intercourse and then later admits to it, but denies that it was forced without consent, it still makes the job of the prosecutor much easier because you don't have to, he or she doesn't have to prove that there was intercourse, which can be a lot of the work sometimes. Okay, remember that your police report is only one part of the package that's going up to the prosecutor.
Tienes tu stereo todavía.
You might have someone's mic is on besides mine. So you may have several police reports that are going up to the prosecutor. One package. You might have the responding officer's report. You might have detective investigative reports, witness statements, actual physical items of evidence, all going to the prosecutor. And your report is just one part of the package. So you have to be mindful of that. For example, when you go to court, you're bringing your reports. You're not bringing everyone's reports. Once you put together your investigation, right, and your report, you submit it to the prosecutor for prosecution, and then you want to cooperate with the prosecutor who's handling the case. Your job is not over once you've sent your reports in. You want to find out if they need anything else, right? Me, the prosecutor, you want to find out if I need anything else. Do you need me to speak to anyone else? Do you need any other exhibits? Do you need any other witnesses? You turn your reports in, and then you want to prepare for testimony. Prepare for your testimony. But remember something important, a practical problem. If you didn't put it in your report, it might as well not have happened. What do I mean by that? Well, if you left a detail out, you're going to court, you're going to have to testify, and you're going to be cross-examined, and now you're going to have to explain why you left out an important detail. So don't leave out an important detail. Take your investigative reports, and if you have to testify, study them, review them before you testify. Look them over. Don't just glance at them briefly. Study them. Now, you want to bring your report to court if you have to testify. But while you're on the stand, you don't want to be reading them. Okay, you want your head to be up, looking at the judge, or the jury, if it happens to be a jury case. You don't want to be reading your report. You want to be familiar with it. The other thing about reading the report is that sometimes officers get into the habit of, well, you know what, I don't really have to familiarize myself with the report. I know the report. And then ends up, not knowing the detail on the stand or having to read. And you don't want to have to do that. But if in fact you've forgotten something, you get asked, well, what did the neighbor tell you? You were called to the scene, you spoke to the next door neighbor. What did the neighbor tell you? Well, maybe you don't remember, and you say that on the stand. Can I look at my report? And so it's okay to look at your report. You just don't want to be reading it throughout testimony. Ask the lawyer who's questioning you. It's going to be either the prosecutor or the defense attorney, right? Can I look at my report to refresh my memory? Because nobody expects you to remember everything. It bothers me more when police officers on the stand either make something up, obviously, or start testifying to what they usually do. So Officer Jones, before you took a statement from the defendant, did you give him a Miranda warning? Well, what we usually do is, I don't want to hear what you usually do. Okay? You either gave a Miranda advisement or you didn't. Okay? Don't tell me what you usually do. Because if you did, you put it in your report. And you read your report before you're testifying. So instead of telling me what you usually do, you're going to say, yes, I gave an advisement. In fact, Mr. Diamond, the card that I read from is attached to my police report. So look over your reports before you testify. Now, the thing is, don't go into a hearing thinking that you don't have to testify to something. You don't have to say something in your testimony because it's all in your report, and that your report is going to be put into evidence, because most of the time your report is not going to be put into evidence because it's hearsay, and the judge wants to hear from you, the words from your mouth, the police officer, the witness. Now there are some hearings where we do put your reports into evidence. Those are usually very preliminary hearings, like the arraignment, a preliminary hearing or an arraignment. And sometimes we'll put the reports in to see, for the judge to decide if there's probable cause, right? But if we have a hearing where there's testimony, an evidentiary hearing, then the report itself is not as good evidence as your words, your testimony, because your testimony can be cross-examined by the defense attorney, by a lay advocate, who's acting as an attorney, and the judge even can ask some questions as well. So don't rely on the fact that it's in your report, so you don't have to say it, because your report itself is probably not going to be admitted to evidence. Now, there are some exceptions to that. There are some tribes that might allow police reports in evidence. Again, that's something to find out. Ask your prosecutor. Ask your tribal prosecutor. Ask your state prosecutor you're working with. Ask your assistant U.S. attorney, do you allow police reports to be admitted into evidence? Something you want to know. But prepare. Now, typically you're going to get subpoenaed to testify if you have to testify. Not always. Make yourself available and prepare. If you think there's a hearing coming up and you don't remember whether you got a subpoena or not, check and make sure. Okay. Now, we've got about, a minute or so left. And, I just want to say a couple of words of gratitude to you for doing this work of investigating sexual violence in Indian country against our indigenous women, or domestic violence and sexual assaults, because you may be saving a life. The amount of violence that ends up being lethality in this field is unfortunately way too common, and so your work is really, really critical. And so I'm grateful that you're doing this work. The National Tribal Trial College and the Southwest Center, we're grateful. The National Council of Juvenile and Family Court Judges is grateful that you're doing this important work. My director, Hallie Bongar-White, is grateful that you're doing this work, and so are your Indigenous victims. Grateful that you're doing this work and taking this course. If you have any last minute questions for me, I should be able to see them in the box here. Certainly you can send me a question at jdiamond@swclap.org. I want to thank you all for attending. I appreciate you attending this conference. Again, thanks to the National Council for hosting us, and to all of my tribal police officers out there. Know that we're with you, we're supporting your work, and I look forward to meeting some of you in person at our future conferences. And we'll be doing another conference next month on gathering evidence. We'll probably be doing these for several months coming up in the future about firearms training, etc. Anyway, to all of you who attended, thanks so much for attending, and I look forward again to meeting you in the future. Bye-bye.